This case has to do with the question, if you are unconscious and you've been arrested for drunk driving, can the police get a blood sample without getting a warrant first? Now, this case is Mitchell v. Wisconsin, and it was decided by the U.S. Supreme Court in 2019. Here's what happened. We've got a defendant who had been drinking and driving. Police went to investigate the situation and found the defendant walking around the beach. His speech was slurred and he was quite unsteady on his feet. They did a preliminary breath test that came back 0.24 BAL, which means he was above the legal limit, but before any further testing could be done, he passed out. At this point, the police took him to the hospital in order to draw blood, to check alcohol levels, and also to make sure that he was okay since he was unconscious. Now, the results from that blood test came back quite a bit above the legal amount that was allowed. The defendant moved to suppress the blood alcohol test results, claiming there wasn't a warrant and he was unconscious, did not consent, and blood alcohol tests do fall under the Fourth Amendment, freedom from unreasonable searches and seizures. Here's what the U.S. Supreme Court did on this particular case. They said, yes, typically you're going to need a warrant when doing a search and seizure, and withdrawing of blood is a seizure of evidence. But in this case, we've got an exception to the warrants clause, which is exigency. And due to the nature of alcohol and what it can do to the human body and questions about the health and safety of the defendant, it could be seen as an exigent circumstance to need to take that defendant to the hospital and have the blood drawn. Exigency exception to the warrant clause, that blood draw is allowed. The court really went into a lot of detail about the dangers of what happens when a person becomes unconscious due to intoxication. That was really the key turning point on this case. If someone becomes unconscious after being arrested for drunk driving, taking blood in that situation is seen as an exigent circumstance and therefore is allowed under the Fourth Amendment.